all. Yes. And just so you know, this pretrial release in Washington, yeah. The law governing personal recognizance, bail, conditions of release, and related matters is the same in domestic violence cases as it is in other criminal prosecutions. Washington general rules are covered in other bench books, and the discussion need not be repeated here. Oh, in Superior Court, we see a Washington State Judge's Bench Book, Criminal Procedure, Superior Court. In courts of limited jurisdiction, see Washington State Judge's Bench Book, Criminal Procedure, Courts of Limited Jurisdiction. Poach. These bench books cover in details matters such as constitutional provisions, statutes, and court rules. Yes. They. Oh my gosh, look at bench books. Now, the respective rights of defendant and state. Personal recognizance, yes. Bail, and conditions of release. Factors to be considered by court, delay of release, release in capital cases, violation of conditions, and failure to appear. In this domestic violence manual, the discussion focuses on the special considerations that should be taken into account in domestic violence cases. Attention is also given to the no contact orders and other special procedures. Yes. That are available in such cases. Now, just so you know, okay, I did search for these bench books. Yes. Cost you $10 as a charge. I know you got elected to office and you wouldn't spend the $10 to get a bench book on exactly what this means. But it seems that when you're making $150,000 to $180,000, you should have bought one of them. Now, if you search for it, okay, you should get a bench book that explains exactly what the requirements of the law are. And then you should look for a copy of the state of Washington. Now, as that citizen that's wanting to sue you, I happen to not have $10. But I just want to make sure that when you say that I did a crime and I say, no, I didn't, and you won't admit the evidence that I wasn't in Sequim, Washington, yes, and then you violate my Miranda rights by doing an interview, yes, then you require me to have mental health evaluations without me being a witness in my own trial. I'm thinking that for every judge that has never purchased one of these bench books, it may be that you thought you did know more about the law than you actually did. Now, could you give me every court website and every bench book of every court in every state of the United States? Because I'm going to sue every judge right now that thought that they did know more than the actual bench book that is used for the laws of the United States. Get me all the IP addresses of all the literature that is available to those in office, because if you RCW 1099 states a defendant arrested for domestic violence shall be required to appear in person before a magistrate within one judicial day after the arrest. Yes. Requires a prosecutor, yes, to provide the following information to the court at first appearance after arrest and arraignment. Now, as an individual that has been arrested numerous times and you violated my personal recognizance, yes, I'm thinking you never bought one of those bench books. You thought that since you were a judge for the last 20 years that you did know all the necessary court procedures, yes, and you didn't have to spend any of your own money once elected to office to buy one of those bench books. Now, I know, relation to that person, that as the additional authority granted court persuading court issue orders restricted right of defendant. Yes. Is it a civil violation of the restraint provisions? Because that would mean a whole lot different than a criminal. And since nobody read me my Miranda rights for the 2-count criminal complaint, yes. Can I be charged? Now, I'm wanting my sons, and I'm wanting to sue each and every judge of the United States that didn't think that they had to know what the court rules are. They didn't have to know the laws. They don't have to know. They're not obligated to understand exactly what the criminal procedures are. It's a little difficult for me to get one. Oh, look at right there. There's a fly. Oh my gosh, it's going in there. Oh, look. Can you see it right there? Yes, there's a fly right there. Do you see that? You know, oh, you didn't have a lizard in your ass last night, did you, Sheriff? You didn't decide to try to choke me, did you? Ooh-wee. Now, I know you would think the sheriffs might want to spend $10 considering all the money. Now, why don't you buy one of those bench books? I think they're available for sale on the state court website. Just get me the check out. Now look at here. Auburn versus Solois. Now, I didn't read that last night, but this is important, isn't it? Violation as a separate crime. Yes. Now, both my public defender and the prosecuting attorney use this. Any knowing violation of domestic violence no contact order is a separate crime. The state must prove violation of the no contact order was knowing as to both the order and contact. Yes. State versus Sizemore. However, personal service of the order is not required. Now, is that the no contact order that was originally issued, or is that the no contact? Well, wait a second here. This is if you got arrested for violating a pre-existing protection order. Right. You did get notice of the court hearings? Yes. Now, just a second. Now, if we go back to bullet point number 2. In other civil proceedings have been commenced, a no contact order may nevertheless be entered. Yes. See, these no contact orders, because I read it yesterday, let's say I had actually committed a crime when I didn't. I go before the court and they said, Paul, there's a protection order against you, but you decided to violate the restraint provisions. Ouch! So we're going to issue an additional no contact order because we arrested you for the civil violating of the restraint provisions of the protection order. Pow, 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 pow. Now, these, if we look at Auburn versus Solois, 119 Washington, the penalties for violation are established in RCW 26.50.110. Absent the circumstances discussed below, violation of a no contact order is a gross misdemeanor. A violation of a no contact order is a felony under certain circumstances. Now, when you look at it, yes, did those individuals have a protection order before the issuance of a no contact order? Must prove violation of no contact order was knowing as to both the order and contact. Shoot, State versus Sizemore. Somewhat confusing, isn't it, when you're thinking about getting arrested for violating a protection order? Yes. Just so that I know, okay, what chapter are we on here? Yes, page, hang on just a second. This is after you've issued a protection order. Yes, it is. And the mandatory language, okay, requires the face of the order bear the legend. Yep. Violation of this order is a criminal offense. You can be arrested. Ow. State versus Marking. The court held that an order without the italicized language was invalid. Now, this is the additional court order that you get after the issuance of a protection order. It's not possible that both the public defender, yes, and the prosecuting attorney could have both been incorrect. Is it possible? I mean, in their motion of the court for dismissal, Jack? Yes. Did you mention that I wasn't given any legal process before the issuance of it? Yes. Did you mention that I wasn't in Brennan, Washington? No. Did you mention that the petitioner didn't sign it? Well, you mentioned to Phyllis that she had a chance to. Poo, 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 poo. Did you mention that there's forgeries of the elected oath of office? Cha-cha-cha. Now, do not mislead. The courts are not required to continually update orders to reflect all statutory changes and penalties for no contact, so long as the orders accurately reflect the statutory notice requirements and do not mislead the defendant. It looks like these no contact orders that may or may not be served, there's something that happens after the protection order. Now, does anybody know what chapter? Now, let's just say, okay, that in Auburn versus absent the circumstances required Auburn versus Solis Marshall. Yes, violation of no contact order is different than a protection order. Yes. You didn't both use the precedent authority, yes, of a no contact order instead of a protection order, did you? Because then I could sue both the public defender of Jefferson County and the prosecuting. Holy shit.